Thank you everyone for joining us. My name is Jie Huang. I am a senior associate at Scott Legal PC. So today we are going to spend some time talking about mandamus lawsuits. Many of you may be curious about how an applicant can use litigation to overcome an unreasonable delay in their case. So just a few things before we get started. Scott Legal is a full service immigration law firm, which means we have expertise handling a wide variety of visa categories suited for various circumstances. So, whatever your immigration needs may be it a family based, employment based, or investment based immigration matter, we can help you find a solution. We will be continuing this webinar series, and we are doing at least 2 webinars a week on different immigration law related topics. And at the end of this webinar, we will be sending out a few things for the benefit of all participants. First, we will send you a copy of the PowerPoint that has all the information that will be covered in this webinar. We will also send you a comprehensive guide with regards to the mandamus action, which we will be discussing today, which is a booklet of information that you can use as a reference. We will also send you a link that you can follow to sign up for the additional webinars that are coming up in the future, and also a link to this webinar as it will be recorded. This webinar will also be made available on YouTube, and we do encourage you to subscribe and hit the notification button as we do regularly upload a variety of immigration law related videos in our channel. Finally, we will send you a link that you can follow to set up a consultation with one of our experienced lawyers should you wish to discuss your case in further detail. So today we are very lucky to have Dustin Saldarriaga, who is a senior associate at Scott Legal, with a wealth of experience in successfully driving forward mandamus actions we will be speaking about today. And he'll be presenting about the option to use federal litigation to compel the government to act when there is an unreasonable delay in your case, and discuss what are the main considerations. Finally, for any questions you may have, please feel free to add them to the chat box or use the Q&A function, and we will try and get to all questions. So without further delay, I will turn it over to Dustin.
Perfect. Thank you, GA, and thank you everyone for joining us for our presentation on mandamus lawsuits. We can go ahead and go to the next slide. So let's start off by clarifying what a mandamus action is. Mandamus is an unusual word. It's not one you hear often, but basically what a mandamus action is a lawsuit asking a judge to make the government do its job. So you're asking a judge to tell the government to do something that the government is obligated to do. So in the context of what we're talking about today, if you have filed an application with the government asking the government to do something for you, to give you a work permit or a travel permit, a visa, a adjustment of status petition, it could be any number of things, and the government is just failing to do that, then a mandamus lawsuit may be a good option to consider. Now, what's important to know is that a mandamus lawsuit is not asking a judge to tell the government to approve, for example, your application. It's just asking the government to do its job. So if the government does its job, it might approve your application, but it also might deny your application, or it might issue a request for additional evidence. So keep that in mind. It might be helpful to think of a mandamus as almost like an expedite request. And in some ways, a mandamus lawsuit has become the expedite process for today, where the government oftentimes doesn't offer another expedite route, even as processing times are getting longer and longer. So if you think about it as an expedite request, obviously, if you're asking the government to do its job faster, it doesn't mean they're going to approve the application. It just means you'll get your decision faster. And that's basically what a mandamus lawsuit does, is it asks the government to reach its decision and do its job faster. Now, a mandamus lawsuit really can be filed against any government, any federal government entity. So it does include USCIS. So if you've, say, filed for an adjustment of status and that's taking a long time, or you've applied for a work permit. So USCIS can be sued. Consulates can be sued if you have a visa application that's been delayed for a really long time at a consulate. You can sue the consulate, the Department of State. You can also sue other government entities. We're not really going to talk about that at this point. Sometimes when it comes into play in the context of immigration is say if you've applied for a visa, it's in administrative processing, and basically, the suspicion is that it's undergoing a security review. You may also add, say, the FBI or the CIA to the lawsuit. You don't necessarily have to, but that's an example where you might add another agency just to say, what we know is this is taking a really long time. We don't know exactly why, but we're asking a judge to just tell the government to do its job, to figure things out on its end. And it could be strategic to also list those other government entities that may be doing, for example, a security check. Um, and as I mentioned, mandamus lawsuits can be used to make the government process a variety of petitions. You see some examples there on your screen. In this presentation, I'm basically just going to use as our example an EB-5 application, which is an investor green card. The process is very similar, regardless of what benefit you're trying to make the government process. So whether we're talking an application for a work permit or a travel permit or an adjustment of status application, whatever it is, the process is going to generally be the same. But when I do refer to specific examples, I'm going to use the EB-5 just because I think it's a helpful example to refer to. So, what makes a strong mandamus case? And really, to put that differently, how long do you need to be waiting for the government to do its job before you should consider suing the government? Um, Suing the government sounds scary. It really shouldn't be. I think that again, it's a helpful way to think about it in terms of an expedite request. And yes, obviously, it is more expensive than a traditional expedite request, and it also is more time consuming than a traditional expedite request. Um, but it, in terms of how the government sees a mandamus lawsuit, it really at this point in practice is an expedite request. So nothing really to be scared of in that regard. Now, it is important, as I mentioned, to think about the costs and how much time is involved. This is a lawsuit, so you would need to draft a complaint, file a complaint with a federal judge, wait for the judge to respond, to reach a decision. If you get to that point, if the government opposes the process, you'll have to have a back and forth with them over that. We'll talk about all this in more detail in this presentation. The reason that I'm bringing this up is it a mandamus is not just a, quick decision to make. Like, you know what, I'm tired of waiting. I just want to go down this process, because it does take time and it does take money. So getting back to the question, how long do you need to wait before a mandamus is appropriate? That does depend on a number of factors, and there's no, you know, bright line rule that says, 2 years is long enough or a year is long enough. It really is case by case. And the reason for that is you do need to imagine being in front of a judge and the judge asking you, okay, so why should I order the government to do something faster than it's doing it now? And you're going to need to come up with your arguments for that. So um, good arguments would include what harm you're experiencing. So if you're experiencing a certain harm as a result of the government's delay, so let's say you are waiting for a work permit and your family's really suffering because you have no way to work. and you have been waiting an excessively long time for this work permit, the fact that your family's being harmed financially really does play into that. Let's go to our EB5 example. Let's say that you are trying to get your green card, and part of that is because the delay is taking so long, it's actually preventing you from naturalizing and being able to vote in an election. So that's a good piece of evidence that you would include in your lawsuit to say, Your Honor, Judge, look at the harm that's happening here. I'm actually being prevented from voting in an election because of nothing more than the government's delay. If you have compelling circumstances showing the harm that's caused by the delay, that could weigh in favor of you filing a lawsuit earlier than you might otherwise if you didn't have examples of that harm. So that's the first thing I'll say is really think about what harm the delay is causing for you, and that is going to be something to include in the lawsuit, and it is something that the judge is going to want to know about. Now, another question, though, is what is typical for this kind of an application? So, the government, USCIS, does publish typical processing times. So if you Google, USCIS processing times for, say, an I-526, which is an EB5 application, you'll see that the government estimates that it could take 5 to 6 years essentially on average for those applications. So that piece of evidence um, does is relevant. It is relevant that the government says it will take, say, 5 years to decide an I-526 petition. But I will say it's not determinative. So in other words, just because the government says it should take 5 years doesn't mean a judge will agree with that. It is something the judge will consider, and they'll say, okay, the government does say that it usually takes this long. And that might make it harder for you to argue that you should be an exception to what the government is claiming is normal. But that doesn't mean, again, that the judge won't side with you. There's a very uh, popular case coming out of the Sixth Circuit Court of Appeals where the court basically says that the government saying that it, takes a snail's pace on every application doesn't mean that a judge should agree that a snail's pace is appropriate. I really like that case. I tend to cite to it in my lawsuits. And it is just a really helpful reminder that just because the government says something will take a long time doesn't mean it should. So another question that you'll need to answer to decide whether you have a strong mandamus case is whether you have used all the other options available to you before you file the lawsuit. So for example, have you reached out to your congressional representative? And if you're outside the country, it might be the congressional representative where the business is located that's petitioning for your green card. Or if you are the spouse of a US citizen, say, the congressional representative for the place where your spouse lives in the United States. Have you reached out to your congressional representative and asked them to contact USCIS to see if they can nudge the case forward? In the past, we would reach out to the USCIS Ombudsman office. That office is it's questionable whether it's still active, but that's another example where in the past a judge would want to see that you really have taken all the other steps you could take before you go to a judge to ask the judge to get involved. And another example, there are a number of factors to decide whether a case is a strong mandamus case, but the other factor that is important is whether Congress has spoken to how quickly it thinks the government should decide the application that you've been waiting for. So fortunately, there is broad language that is in a statute that basically says that Congress thinks the government, I think it's 6 months is typical for a non-immigrant benefit, a non-immigrant visa or a non-immigrant, say, change of status. So and it has a similar time frame for an immigrant benefit. Um, so you can cite to that statute. That statute carries less weight, frankly, because it is quite a broad stroke statute. But the the question, the answer to the question, has Congress spoken to this, is oftentimes yes. Oftentimes Congress has spoken to how long it thinks the government should decide these applications within. And if the government is exceeding that time frame, that weighs in your favor. So the way, taking a big step back, when we're looking at what makes a strong mandamus case, there is a framework, and the name of that framework comes out of a case called TRAC, TRAC. And these are called track factors, TRAC factors. And there are a number of track factors. I believe there are 6 in total. And they look at things that include harm that you've suffered as a result of the delay. They look at things like, has Congress spoken to the issue? They look at things like, does the government have competing priorities, and say limited resources where they can't let you skip, say, the line. The government will make all of those arguments opposing your application, your lawsuit, but you in the lawsuit will need to make the initial arguments that are basically saying, based on all the track factors, here's why my argument that the delay is unreasonable is the right argument. So the track factors really are going to be what controls this when you've actually filed the lawsuit. So what is the process? So we mentioned before that you'll want to exhaust other options. So for example, reach out to your congressperson and be ready to show the judge that you actually did reach out to the congressperson, their name, the date you did it, what the response was. You don't necessarily need to put all that in your complaint, but it is good to have that information readily available, particularly if the government comes back in response and argues you should have done more. They're not likely to do that, but it's good to have clear records when you're filing this lawsuit. So once you've exhausted all other options and you decide, you know what, it's time to actually file this lawsuit, the first step is to draft the complaint. So what the complaint does is it lists out all of your facts. It explains why you're filing this lawsuit, the date that you applied for the benefit, how long you've been waiting, what the harm you suffered is. There are different approaches on whether the complaint should be very streamlined and simple, where it's just making basic allegations, or if it should be a little more detailed and actually starting to make some of the more robust arguments in anticipation of what the government will. There are valid arguments for both approaches, but the fact is that step one really is preparing that complaint. And the complaint is going to lay out for the judge that you have a valid lawsuit on the face. So basically, assuming that everything you're saying in the complaint is true, you have a valid lawsuit. The complaint is also going to show the government what they need to respond to as they oppose your lawsuit. So you'll file the complaint with the federal court. You will then serve the complaint as well as the summons on the defendant. So the defendants are typically USCIS will have a defendant. If you're suing a consulate, the Department of State will be a defendant. Again, if you are suing another agency, typically you wouldn't, but if you were suing another agency, you would serve them as well as the U.S. Attorney General. So the government is going to be represented by the Department of Justice. So keep in mind that you or your attorney will be on the other side of the Department of Justice, and it will be the Department of Justice that's opposing your lawsuit. Again, that shouldn't be intimidating. It's very common to do this. The Department of Justice typically does have very good lawyers, but that actually in many ways helps you. because it means that they are quite responsive, and they want to do their job well, usually. And they also, oftentimes, what that means is exploring settlement as an option. So they're not necessarily always going to be, directly opposing your lawsuit. Many times they will say, I don't want to spend time going to court on this. I want to settle this because I have other cases I want to work on. So they will oftentimes try hard to get on the phone with the USCIS or the Department of State and ask the government officer whether it's possible to actually just get this job done so that they don't have to work on the lawsuit unnecessarily. So let's go back to the process. So you'll serve the complaint and the summons on the defendants. Once they receive the complaint and the summons, they have 60 days to respond to the complaint. So usually nothing is going to happen within about 2 months of you serving the government. Um, Oftentimes it's longer than 60 days. And the reason is what usually happens is in the last week of that 60-day period, you're going to get a call, or your lawyer is going to get a call from, or an email from the government attorney, the Department of Justice attorney. And the attorney is going to say, hey, I've just had a chance to look at this. I'm really not going to have time to respond within the 60 days. Can I have another, 30 days? Um, and almost always you should say, yes, you can have another 30 days because uh, you are probably going to need more time and you are going to want them to give you more time. And also, the judge wants to see the parties working together. And if you tell the government, no, we're sticking to the 60 days, you don't get more time, well, the government attorney is going to go to the judge and ask the judge, and the judge is going to say, didn't you ask the other side and didn't they give that to you? And if they say, yeah, we asked and they said no, the judge is going to get mad at you. So you want to be accommodating, a good sport, work with the other side to reach a resolution. So what this means in terms of the timeline is it is oftentimes at least 90 days from the date that you serve the government before you really get a substantive response. And what I mean by a substantive response is either settlement, where the government attorney will have reached out to USCIS or to the Department of State, and it turns out that yeah, they're willing to actually turn their attention to your application and reach a decision. And that is always wonderful when that happens. It feels great. The lawsuit was efficient. You don't have to keep fighting this. You don't have to keep paying to fight this, and you've resolved things. So it's wonderful when that happens. That does sometimes happen. Um, uh, but it doesn't always happen. And if the government doesn't want to settle, usually what they're going to do within that 90-day time frame is they are not going to actually file an answer to your complaint. They're not going to directly respond to your complaint. What they're oftentimes going to do is file a motion to dismiss. And a motion to dismiss is basically them telling the judge, Your Honor, assuming that everything the other side has said, meaning you, everything you've argued in your complaint, assuming all of that is true, they still don't have a case. And that the motion to dismiss is actually a quite high bar in general to meet, because again, the judge is supposed to assume that all of the facts you've alleged in your complaint are true. So it is a fairly high bar. That being said, sometimes motions to dismiss are granted. So you do want to make sure you have a solid complaint that addresses, at least on the face, all of the legal arguments you need to make. It does allege clear facts that, if true, would support each of your arguments. That's why putting time and effort into the complaint is important. Now, one thing I will say is it is possible to amend your complaint, and you actually can amend, in general, you can amend your complaint without even asking permission, really. You have a right to amend based on the rules of civil procedure. So if you did want to initially file a very streamlined short complaint that really does just hit all you have to hit, but really nothing more, and then if the government responds, you can then amend your complaint to address some of the things that they argue in the motion to dismiss. That is a fairly common thing to do, and is strategically is something you could do. Say if you wanted to try to reduce your costs on one of these cases, you might speak with your attorney and say, I want to do a very streamlined initial complaint, and then only after we know if the government's going to fight, then we can amend the complaint and spend more time on it then, rather than spending that time and money at the beginning. There again, strategically, there are reasons to do both. From a financial standpoint, it might be good to do a more streamlined complaint. And on that note, I will also just quickly say, you do have, in general, you do have the right to withdraw your complaint. So you know, even though it is good to have the long term in mind and to realize, and you should be willing to fight the lawsuit. You should not be filing what we would call a frivolous lawsuit, where you're not actually wanting to fight. It's more a threat. And then if you see they want to fight, you're going to withdraw it. That's in general not good to do. Um, but that being said, if it turns out that the government really does start fighting in a way you were not anticipating, then you can along the way decide, you know what, we're going to withdraw our complaint and we're just going to go back to waiting for the visa or the benefit, whatever it is. Um, Now, the last bullet you see on your screen is the judge's decision. Now, these cases uh, almost never get to what you've probably seen on TV in terms of, both sides arguing in front of the judge and referring to Exhibit A, and you read things, and these cases just don't tend to ever get to that point. And the reason for that is that the government does not want to disclose documents. The government does not want to engage in what's called discovery. They also don't want to engage in depositions. So usually what will happen is the government will file its motion to dismiss, which we talked about before, and you will oppose the motion to dismiss, and then the judge will decide whether you actually have a case or not. And again, that is supposed to be a high bar for the government to meet. So the odds should be in your favor in general on that. If the judge decides that you win and the case is not going to be dismissed and we're going to move forward with the case, basically what that means is that the government now needs to respond to the complaint. And again, that usually doesn't happen, because once the government sees that the judge is not going to dismiss the lawsuit, what oftentimes will happen next after they respond to the complaint is you get to do discovery. You get to say, okay, government, I want documents on all of your correspondence about this application. I want information on all of the other applications so that we can see if there's actually a line here. How many people are waiting in the line for this visa? I want to see when you approved each one, the dates and the decisions, so that we can actually see, do you follow a first in, first out process? And what you're basically doing is you're taking all of their representations in the motion to dismiss, and you're testing them to see if they're true. So you said there's a line, and you said we shouldn't cut the line. So prove that there's a line. We want to see documents proving there's a line. And you know what? Why don't we actually have the official in Washington, D.C., be deposed so that they are in front of a video camera answering questions about their procedures? No government official wants to do that. And historically, the government will not put its officials in that position. So that's a good thing for you in general, because it usually means once the motion to dismiss is decided in your favor, the government will settle. So that is almost always what will happen is if they file a motion to dismiss and you win on the motion to dismiss, the government will almost always settle at that point. If they don't settle, it is in general uh, good for good in a broad sense because what that means is we would get to do discovery and it would be good to know more about the government's processes. But for you as the individual, you always kind of do want settlement because again, this is a process that's time consuming and expensive, and you really are going to be paying for every part of this process. So an early settlement for you in general is a good thing. Um, so I do hope that makes sense. If you do have questions, feel free to send those in. I'm happy to talk about the process in more detail if there are questions. All right, so let's go through a few of these common questions. I've touched on a few of these already, but let's go ahead and dive in. So, can I file a mandamus action to compel the government to approve my petition? The answer is that would not be a mandamus. Again, think of a mandamus as an expedite. So you are asking the government to reach a decision. You're not asking the government to approve or deny or issue a request for evidence. You're just asking them to do their job and issue a decision. If you did receive a denial and you want to challenge that denial, you can file a lawsuit to challenge the denial, but that's not a mandamus lawsuit. It's a very different lawsuit. It has a different framework. It is very much dependent on the specific benefit you're applying for and what amount of discretion the government has in reaching its decision. Um, if you have a denial from a consulate, you basically cannot challenge it in a court, but if it is a denial from USCIS, those can be challenged in general. But that's not what we're talking about today. We are talking about a mandamus lawsuit, which again is essentially a form of expediting an application. How much time must pass before the delay is unreasonable? So again, this comes down to a number of factors. The first thing I always recommend my clients think about and share with me is the harm that they're facing. And if we do have a very compelling harm, if we're talking about medical issues, if we're talking about a family being able to survive financially, if we're talking about a family being together physically, someone being able to vote in an election. To me, these are very compelling forms of harm, and I think that a judge would oftentimes find them compelling. So the absolute amount of time is less important if you really have these compelling forms of harm. Now, the amount of time is relevant. So when we do get to that point, you want to see, well, has the government spoken to how long it should take? If the government has spoken to how long this application usually takes, and you've been waiting longer than that, there's a very high likelihood that the government will settle. So taking the EB-5, if you filed the I-526, which the government says should take on average about 5 years or so, which we think is absurd, but that's what the government says, and you've been waiting 7 years, there is a really good chance you file that lawsuit and the government will say, okay, we'll settle on this one. You know, you've been waiting longer than even we say you should be waiting. And so that is a great thing if you've been waiting longer than the published processing times. But if you haven't been waiting longer than the published processing times, it is definitely possible to win that lawsuit. You just need to be more strategic about it. You need to um, look into how long it really should be taking the government. So, has Congress spoken to how long it should be taking the government? One of the wonderful things about suing the government is that the government is obligated to disclose quite a bit of detail and data to Congress. So, just to take an example of this in the EB-5 context, and frankly, it's not just EB-5, it's really any benefit, any petition, work permit, a travel permit. USCIS has disclosed to Congress periodically um, how long it takes them to decide these applications in terms of hours. So we're not talking, say an EB5 application taking 2 weeks to decide. We are talking a matter of hours. So you take that data, USCIS has disclosed it takes, for example, I'm just picking a number, say 12 hours to decide this application, and they are estimating it takes 5 years. There's a discrepancy there that the government should have to describe to explain. And until they do explain it, that is unreasonable. That's our argument. So you would have to get into those details if the processing time is within the government's published processing times, if the amount of time you've waited is less than what the government has published as the estimate. Um, this next question, how long does it take for a mandamus action to be decided? That really depends on how hard the government is fighting against you. If you've been waiting longer than the published processing time and they want to settle, it is possible, and we have seen settlements within 2 to 3 months of filing the complaint. That doesn't mean that will happen in the future. It doesn't mean it will, happen regularly, but it has happened, and it is possible for it to happen if you have a compelling case and the government wants to settle it. If the government instead wants to fight and they file a motion to dismiss, it is usually 90 days before they even file their motion to dismiss, and they're probably going to ask for an extension on that as well. Once they file their motion to dismiss, you are going to have a few weeks to respond to it. And then sometimes they will be able to respond to that. So that process of filing the papers with the court can take 3 months to 4 months or so. And then once all the papers are filed with the government, with the judge will take time to decide. And judges cannot, there is no mandamus for a judge. Unfortunately, judges have the ability to take pretty much as long as they want to decide these. In our experience, judges will reach a decision within 6 to 9 months of having all of the papers. So from start to finish, I would say if the government does file a motion to dismiss, you are typically looking at, I would say, about a year at least, maybe a year and a half. So keep in mind, this is not the fastest process. It is using a federal court. So it can be slow, but when you're looking at an EB5 application where the government is saying, you know what, we think it's going to take 5 years, and in practice, it'll sometimes take 7 years or so, waiting a year to a year and a half for a judge to make the government do its job, relatively speaking, can be a good strategic decision. This next question is an important one. It comes up a lot. Won't the government simply deny my petition or retaliate against me if I sue them? So in practice, the answer is that the government does not typically deny a petition or retaliate against someone who sues them. Again, the government tends to see these lawsuits as expedite requests. That's the first thing I would say, is that because the government's processing times have become just so extreme, they have only grown with time, oftentimes as the number of applications has actually gone down, that mandamus lawsuits are actually quite common. The second thing I would say is that it does assume some level of coordination on the government to be able to retaliate. And we typically don't see that level of coordination. The government usually is not really thinking about what its right hand is doing. The left hand's not thinking about the right hand necessarily. So the final thing I would say is that it is inappropriate for the government to retaliate in the face of a lawsuit. So historically, we have not frequently seen retaliation happening. Our firm has never seen retaliation happen. But that being said, we are in a new administration that is hostile toward applicants in a way that the government never has been in the past. So could it happen? It could happen. The government could retaliate. And you should be aware that there is some risk of that. In practice, we do think the risk is very minor. And we do think it is strategically a good idea to go forward with a mandamus depending on the circumstances. But you do need to be aware the government has been doing things that are unprecedented, and they certainly could ramp up retaliations against those who sue them. Um, my delayed application is with a U.S. consulate. Can I file a mandamus against a consulate? You can. So the important thing here is, again, a mandamus is asking the consulate to do its job, which is perfectly fine. You can file a mandamus asking the consulate to do its job and to basically expedite the process. What you cannot ask a consulate to do is to reconsider its decision. So if a consulate has denied your visa, you cannot sue asking them to approve the petition. So the reason for that is there is something called consular non-reviewability. The Supreme Court, the U.S. Supreme Court, has basically decided that consulates' decisions are insulated, and courts will not look at the reasons for a denial for a decision. So it is unfortunate. This came back to the Supreme Court just a few years ago in a case called Munoz out of the Ninth Circuit. Went to the Supreme Court, and the Supreme Court again said, yeah, consular decisions are not reviewable by a court. I'll just briefly say, there may be ways to challenge that. I don't think it's worth spending much time on that in this presentation, but you can imagine a situation where there is just explicit bias, or there is explicit prejudice in a decision, and you have, documentation showing that the consulate made a legal error. If you're in that kind of a situation, it might be worth suing the consulate on its decision, but odds are you're not going to have that, and so it's not going to be worth suing a consulate. Should I work with a lawyer if I decide to file a mandamus action against the government? I would say yes, you should, and the reason is this is this is litigation in a federal court. So federal courts, each federal court has its own procedures. The federal court in Connecticut is different from the federal court in Manhattan, which is different from the federal court in Western New York or Eastern New York or Northern New York. So each court has its own procedures that you need to be aware of. It is a quite complex area. You also, the other thing that's important to understand about this is it's not just, you know, litigation. It's not just arguing in front of a judge and filing papers with a court. It is also actively negotiating with the assistant U.S. attorney. So you also need to understand what the assistant U.S. attorney's priorities are so that you can nudge them to try to settle the case while the lawsuit's going on with the judge. So this is a complex area. Judges can be very temperamental, meaning that they want the rules of their courthouse and their chambers, their courtroom followed closely. So, it is worthwhile to have a lawyer who knows how that's done and can work with the judge and can work with the government to reach a resolution for you. All right, we did have a couple questions come in while we were talking, so I have not read them, so we'll see. We'll see if I can answer them on the spot. But please, while we're going over these two, if you do have other questions, feel free to send them in. I'd be happy to discuss them. So, what if the applicant is in India or Pakistan coming to Florida? You are in New York. How can you proceed for an E2 visa? Oh, so good question. I'm going to set aside the visa types because the answer is more of a general one. So, fortunately, U.S. immigration law is federal. We are not talking about law that is specific to a state. So what that means is as long as either you as the applicant or the beneficiary or the government has ties to a certain state, you can file the lawsuit in that state. So this person is saying you're coming to Florida. So I'm assuming that means either the business that's sponsoring you is based in Florida, or if it's a family-based petition, let's say it's family-based, that the sponsoring individual, whether a permanent resident or a citizen, is based in Florida. So Florida may be the best court to file in. This is part of what we do is we look at the different courts that you may be able to file in, and we strategize with you um, based on the cases, the decisions that are coming out of that court, whether they tend to be favorable or whether it's a relatively hostile court. But you may have options. You may be able to file in New York or say Washington, D.C. And that's a strategy to figure out, should we go with DC? Should we go with Florida? So we are based in New York, but uh, we have had lawsuits all over the country. And the way that that works is first of all, our attorneys are licensed in different courts. So I am licensed in Massachusetts and New York. But more relevant here is that federal courts oftentimes will have a process called pro hoc vice, which allows basically an attorney to visit the court for the purpose of a lawsuit. Each court has a different process. Some courts are very easy where I could just go online and register with the court and then file a lawsuit in that court. Um, or some have more involved process where there needs to be an attorney. Let's take California, for example. This, if I remember correctly, the Central District of California, um, you need to find an attorney in the Central District, and we can do that. We have peers all over the country, and that peer attorney would say, yes, I'm based in Central District and I will be essentially your sponsor for this court. So they'll say, they will basically join the lawsuit with you as the local attorney, but we would be the ones essentially doing all of the work. We just do have a representative on the ground who's responsible to the court should the court want a local attorney to be responsible. So the answer is, in general, there is no problem with filing really anywhere in the country. If we're not personally barred in the state, then we can look at the process to go through pro hoc vice, the pro hoc vice process. And if we needed to have a local attorney, we are part of a very large network of litigators, and regularly do that. So it's not a problem. So, what sort of mandamus cases have you filed and what were the results? Happy to talk about that. Always have to say that past results don't predict the future outcomes. So even though we actually have had great success with our mandamus lawsuits, um, that doesn't mean that that's going to predict the next lawsuit. We always do have to make that very clear. But that being said, our litigation has focused primarily on EB-5. So these are the investor immigrant visas where you invest $800,000 or uh, $1 million, and you get a green card basically through that investment and the creation of jobs from that investment. And we have had lawsuits that are both on the initial petition, the I-526, which is what the government estimates takes 5 years or 6 years at this point. Um, and we've had successful lawsuits on the later part of that process, which is removing the conditions on the green card. For an EB-5, you file the I-526. If that is approved, you file the I-485, the application for a conditional green card. Then you get a green card, but with conditions on it, meaning that in 2 years, you need to go back to the government, show them you've actually met all the requirements, and then they remove those conditions and they give you a permanent green card. So that phase where you're applying to remove the conditions, we have had successful lawsuits on that. as well. And that's an example where you can pull in arguments like the government's delay is actually keeping this person from becoming a citizen and voting, which is something they really want to do. So you do want to think about the arguments you can make. Um, I think there was another question about the timing. I'm not. Yeah, yes, I think it was just an add-on to the first question, so not a problem. You all, if you have access to the internet, you can look at what the estimated processing times are for USCIS. You would just Google USCIS processing times, choose the form, and you would see what the government estimates is the processing time. It's a little confusing because they don't give you an average. What they give you is the amount of time it takes them to complete 80% of the pending applications. So already what they're showing you by that figure is a delayed figure. So we like to make that argument that if we file a lawsuit and the government comes back and says, "Oh, but it's within our processing time," then one of the first things we'll say is, yeah, but your processing time is delayed by definition. It's like how long it takes you to decide 80% of them. So that includes, those that are delayed. It's not an average or a median. So anyway, Gia, were there any other questions?
No, I think we have answered all of them. Thank you, everyone, for your
Perfect.
participation. And thank you so much, Dustin, for all of your insights. I'm sure this was very helpful to our audience. And yeah, please, everyone, reach out to us if you'd like to set up a consultation to discuss your case in further detail. Thank you, everyone. Have a great, wonderful day. Thank you so much, Dustin, for your expertise.
Thank you. Have a great day.